There is a specific type of authority that operates entirely on the assumption that it will not be challenged. Not the authority that has been tested and survived scrutiny. Not the authority that has been questioned and answered the questions. The authority that has simply never had to. The authority built on decades of deference, on the accumulated weight of a title and a robe and a raised bench and a gavel and the social understanding, absorbed by everyone who enters the room, that this particular person is the one who decides when you speak, how long you speak, and whether what you say is going to be treated as relevant or dismissed before you finish the sentence. That kind of authority has a specific fragility to it, because it has never been stress tested. It has been maintained through compliance, not through genuinely earning the right to it. And when someone enters the room who did not receive the message about compliance, or received it and consciously decided to ignore it, the entire architecture of that authority becomes visible in a way it never has before. Visible and therefore vulnerable. What happened in that federal courtroom was not supposed to happen, and the fact that it did, and the way it unfolded, and the specific words that were spoken before the gavel came down and the bench emptied, all of it has been sitting in the public consciousness since the moment it occurred, spreading with the specific velocity of a moment that makes people feel something true has been said out loud. This is the story of that moment. Judge Howell did not project authority. She carried it. There is a distinction worth making. Projection is performance, the raised voice, the theatrical impatience, the deliberate construction of an impression of power for an audience. Carrying authority is different. It arrives before you do. It exists in the reputation that enters the room ahead of your physical presence. In the years of courtroom history that every attorney who has appeared before you has absorbed and passed on to the next attorney who is preparing for their first appearance before you. Long explanations got cut short. Emotional arguments were redirected before they could build momentum. Anyone who seemed to be performing for the gallery rather than speaking to the court found the floor removed from under them before they reached the second sentence. The system worked because the system was consistently enforced, and people who operate within systems do not tend to challenge them as long as the system acknowledges their presence. The message for attorneys entering her courtroom was not spoken. It did not need to be. It was in the posture of every lawyer who had appeared there before, in the careful, abbreviated precision with which experienced counsel presented their arguments, in the specific way people did not make eye contact with the bench unless they were invited to. Order in this room was maintained through the implicit understanding that order was non-negotiable. When Jasmine Crockett walked in, the implicit understanding had not reached her in the form that the room was built to transmit it. Not because she lacked experience with courtrooms. The opposite. Crockett had spent years in the kinds of courtrooms where clients showed up with their hands shaking because they could not afford to lose. Emergency injunction hearings at midnight. Small rooms in buildings that smelled like fluorescent lighting and bureaucratic defeat. Standing next to people who were frightened and had no margin for error and needed someone at the counsel table who understood that this was not an academic exercise. The law she had learned was not learned in the comfortable altitude of law review articles. It was learned in proximity to the actual consequences of what happens when the law fails to protect the people it is supposed to protect. That background produces a specific quality in an advocate. It produces someone who does not experience the authority of the bench as inherently legitimate, but as something that has to justify itself by the quality of its engagement with the constitutional arguments being presented. Someone who understands that the purpose of the courtroom is not to protect the comfort of the institution, but to provide a venue for genuine justice, and who treats any deviation from that purpose as worthy of challenge rather than deference. She was not polished by the networks that produce a certain kind of Washington attorney, the kind whose roughest moments have been losing a filing deadline rather than losing a client's housing or their vote or their access to the ballot. She had a different kind of experience, and that experience had given her a different kind of calm. The hearing was formally about voting access legislation, about specific provisions in specific laws, early voting windows, mail-in ballot access, identification requirements that civil rights advocates argued were designed to achieve through administrative mechanism what could no longer be achieved through direct restriction. Not the blunt instrument of historical voter suppression, but something more precise and more deniable, the calibration of procedural barriers to fall most heavily on communities that have historically been most effectively excluded. Crockett opened by naming what was happening, not dancing around it, not building toward it through several paragraphs of qualifying language, not framing it as a theoretical concern about potential downstream effects. She named it directly. These laws suppress votes. They are designed to suppress votes. The fact that they do not contain explicitly discriminatory language does not change the outcome they produce, and the outcome they produce is the one that matters. The judge interrupted. The language that came from the bench was the language she had used successfully to interrupt 1,000 previous arguments. This is a legal proceeding, not a political forum, and the court would appreciate counsel staying within the boundaries of relevant legal argument. Crockett's response was not the response the room expected. She said, steady, unhurried, without hostility but without apology, that when courts described constitutional arguments about voting access as political theater, they were engaging in a double standard. Government lawyers arguing for the laws faced no such characterization of their arguments as politically motivated. The moment advocacy appeared from the other direction, suddenly the courtroom was in danger of becoming a forum. That asymmetry, she said, was not a neutral feature of legal process. It was itself a reflection of the problem. The words produced an immediate atmospheric change in the room, not dramatic noise, the opposite of noise. The particular silence of a space full of people who have just heard something said that has not been said in that room before, and who are collectively registering the implications of what it means that it has been said. She moved into the substance. Charts, not activist projections. Data from independent election analysts, figures on how specific provisions affected specific communities in specific measurable ways. Early voting restrictions reducing urban participation by double digits. Mail-in ballot limitations producing the steepest drops among elderly and disabled voters. Identification requirements concentrating their impact on communities where the gap between holding an ID and being able to obtain one is not theoretical but structural. She held the materials up so they could be seen. She requested they be entered into the record. The judge's response was dismissive. Statistical projections, she said, were not relevant to statutory interpretation. Crockett came back without hesitation. They are relevant when the outcome of the interpretation you are construing produces the measurable constitutional harm these projections document. Relevance is not determined by the convenience of the conclusion the evidence points toward. Then she moved to precedent. Brown, Reynolds v. Sims, Harper v. Virginia Board of Elections. She delivered them in sequence, quickly, the specific velocity of someone who is not listing citations for the court's information, but firing them as structural arguments, each one building the evidentiary architecture of why the laws under consideration could not survive constitutional scrutiny. Each case landed with the specificity of preparation, not cited broadly for their general relevance to civil rights, but for the precise constitutional reasoning they contained that applied directly to the specific provisions being challenged. The judge threatened contempt. The word is designed to end conversations. It carries the weight of institutional consequence fines, removal from the proceedings, the professional and personal cost of being seen as someone who crossed the line a court had drawn. It is a threshold word, and attorneys who are weighing their career against their argument tend to retreat when they hear it. Crockett did not retreat. She said she was presenting precedent. That presenting precedent was her legal obligation. That threatening contempt for the presentation of controlling case law did not alter the content of that case law or its application to the matter before the court. And then she said something that reversed the pressure in the room in a way that no one who was present has forgotten. What is happening here, she said, is not disorder. It is discomfort. The discomfort of having constitutional violations named precisely in a forum that would prefer the naming to occur in more polite terms or not at all. The bench is not made untouchable by the robe. The gavel does not transform institutional preferences into constitutional mandates. And the threat of contempt does not change what the Constitution says about the rights of the people sitting outside this building waiting to find out whether their access to the ballot is going to be protected or progressively eroded by laws that have been constructed precisely to be difficult to challenge. She raised her hand. A simple gesture, physical, visible, unambiguous in its intention to speak over what was about to arrive from the bench. In the context of that room, in that specific moment, the gesture had the quality of an act of reclamation, the reclamation of the floor, of the right to finish a constitutional argument without being cut off, of the principle that the substance of what was being said deserved to be heard. The judge stopped mid-sentence. Crockett said what she said in the silence that opened. She talked about the Constitution not as a document that created the bench, but as a document that created everything in the room. The judiciary, the legislature, the executive, the entire architecture of American governance, and located power not in any of those institutions as ends in themselves, but in the people from whom those institutions derive their authority to function. The bench exists because the Constitution authorized it. The Constitution was authorized by the people, which means that the people's constitutional rights are not a disruption to the proceedings of the court. They are the reason the court exists. To dismiss constitutional harm as political noise, therefore, is not to protect the integrity of the legal process. It is to invert it. It is to use the instrument that exists to protect the people as a shield against the people's legitimate claims. She asked the question that everyone in the room had been circling without asking directly. If constitutional arguments cannot be heard in a federal courtroom, if the place where citizens are supposed to bring their most fundamental grievances about the violation of their rights becomes a room where those grievances are interrupted and dismissed and threatened into silence, then where, exactly, are those citizens supposed to go? What is the alternative being offered when the courthouse door is functionally closed to constitutional accountability? The room received this in total silence. What followed had the quality of a structure giving way under load it was not designed to handle. The gavel came down hard. The judge announced a recess. The chair scraped against the floor with the specificity of a movement made too quickly for it to be composed. Not the controlled pause of a jurist managing the pace of proceedings, but the involuntary physical response of someone who needed to leave the room. The side door opened and closed. The bench was empty. Crockett stood at the podium. She had not moved during any of it. She had not stepped back from the microphone or gathered her materials into a defensive posture or looked toward the gallery for the validation of reaction. She stood at the podium the way she had been standing since she began, grounded, present, facing a bench that was now vacant, her composure unchanged by the emptiness in front of her. The room then converted itself into something different in real time. The contained tension of a courtroom became the released energy of a moment that people were already processing into the language of transmission, what they would tell people, what clip they would share, what single line would carry the weight of the entire exchange when condensed into the 12 seconds that social media requires. The Constitution does not end at your bench. The line was in the air before the reporters reached the hallway. It was on screens before the building's outer doors had fully closed. It was trending before the recess ended. The aftermath moved in multiple directions simultaneously, each one producing consequences that outlasted the news cycle. Legal organizations responded within hours. The documentation of what Crockett had said, the precision with which she had cited precedent under sustained judicial pressure, the specific way she had held the floor against a judge whose courtroom had not seen that kind of resistance in recent memory, all of it was analyzed and praised and disseminated through the professional channels that influence how the legal community understands itself. Civil rights organizations moved equally fast. Voting rights groups and civil liberties advocates saw in Crockett's arguments a public articulation of what their litigation strategies had been building toward for years. The precise constitutional case against administrative voter suppression made in the most visible possible forum, under conditions that demonstrated the difficulty of making that case and the necessity of making it anyway. The political response was quieter but equally consequential. In Washington, the people who tracked the trajectory of careers understood what they had witnessed. The Congresswoman who had gone into a federal courtroom and not only refused to be silenced by a judge threatening contempt, but had turned the threat into an indictment of the institution's failure to take constitutional accountability seriously, that person was now carrying a different kind of weight. Not the weight of controversy, but the weight of having been right, publicly and precisely, in a setting where the cost of being wrong would have been severe. Inside the judiciary, the reverberations were less visible, but arguably more significant. Judicial training conversations that had not previously included the question of how courts handle high-profile constitutional advocacy under public scrutiny began to include it. The specific failure of judicial composure on display, the gavel slammed down, the chair scraped back, the room vacated, became a case study in what happens when authority that has relied on deference encounters someone who will not provide it. The lesson was not comfortable, but it was clear. The legitimacy of judicial authority is not inherent. It has to be maintained through the quality of the court's engagement with the arguments before it, not through the suppression of those arguments. Crockett returned to Capitol Hill, carrying the momentum of the courtroom into the committee hearings that followed. When witnesses in subsequent hearings attempted the familiar techniques of evasion, the non-responsive answer, the redirect toward more comfortable ground, the implicit reliance on the expectation that the questioner will eventually accept less than a direct answer. They encountered someone who had just spent an afternoon demonstrating, in front of cameras and reporters and the full institutional weight of a federal court, that she would not accept less than a direct answer. She said it plainly in one of those hearings, without fanfare, as though it were simply the obvious thing to note. She had spent a full day explaining constitutional precedent to a federal judge. The witness's evasion was, by comparison, relatively modest in its ambition. The room laughed, but the point was made and received. What lingers about that courtroom moment is not primarily the confrontation itself, vivid as it was. It is what the confrontation revealed about where power actually lives in the constitutional architecture, when someone is willing to locate it honestly. The bench is high, and the robe is authoritative, and the gavel is loud. The accumulated cultural weight of judicial authority is real and substantial and not easily dismissed. All of this is true. But the Constitution, the actual document, the one that created the courts and defined their authority and established the rights that courts are supposed to protect, does not belong to the institution. It belongs to the people whose rights it guarantees. And when someone stands in a courtroom and says this plainly, not as a rhetorical gesture, but as a constitutional argument backed by precedent and evidence. The institution faces a choice between engaging with the argument honestly or retreating from it. The bench emptied. The argument remained. That is what people saw when the clip circulated. Not a politician performing outrage for her base. Not an attorney overstepping the boundaries of professional conduct. A person who understood exactly what the Constitution says about who it belongs to, standing in a room where that document's authority was being tested and refusing to pretend otherwise. The question she asked before the room went silent was not rhetorical. If constitutional arguments cannot be made in the courthouse, where do people go? The system has not yet provided a satisfying answer. Crockett kept asking, subscribe, and stay with this conversation. Because the people asking hard questions in difficult rooms deserve an audience that is paying attention.